Hello, my name is Michael Kemmy. I'm an attorney and I'd like to talk to you about living trusts and estate planning and how to avoid probate and save estate taxes. You may have heard about trusts and probate and estate taxes, but you may not really understand what they are or whether they are important to you. All the legal terms and technical rules can be pretty confusing, but I'll try to keep the jargon to a minimum. In this program, I'll be talking to you about estate planning for your life and for your death. I'll explain what a trust is and how trust can protect your assets during your lifetime and how you can use trust to avoid probate and save estate taxes at your death. Of course, we'll cover other related topics as well. This program is not intended to replace the advice of an attorney who can better guide you on specific situations that best suit your individual needs. Instead, this program is designed as a guide to increase your knowledge so that when you sit down to talk with your estate planning advisors, you'll better understand some fairly sophisticated estate planning concepts. You'll be able to more effectively participate in forming your own estate plan. This program is divided into several sections, each numbered and color-coded. If you want to take notes for future reference, you might want to write down the particular section number so you can go right to it when you review the program. So, if you're interested in helping yourself and your loved ones avoid some of the trials and expenses of probate while leaving them a greater inheritance by reducing your estate taxes, let's get started. Your estate is simply all the assets you own at any particular moment. It consists of your home and other real estate, your furnishings and automobiles, your bank accounts, stocks and bonds, life insurance, retirement plans, and all the rest of your property. Normally, when we use the term estate, we think of the estate of a deceased person, but it can also refer to all of your assets or property while you are living. Why is it important to have an estate plan? You've worked hard for everything you have, and without a good estate plan, much of it could be lost. If you don't have your own estate plan, the state will control what happens to your property if you become incapacitated and when you die. The state does not take your property, except in rare cases, but it does control who manages it and who gets it upon your death. In addition to that, without an effective estate plan, your estate could end up paying hundreds of thousands of dollars in taxes that could have been avoided. Not the one you want. So it is important to understand and take control of your own estate plan. Your estate plan should be designed with your goals and priorities in mind. Most people want to protect their assets in the event of incapacity during life and want to direct who takes their property upon death. In addition, many people want their estate to pass to their loved ones as efficiently as possible and make sure that Uncle Sam gets as little as possible. And since you have an estate to protect during your life and upon death, a good estate plan will cover both phases. For ease of reference, let's call them lifetime planning and death time planning. With the living trust as part of your estate plan, you can avoid or reduce the problems associated with guardianship, probate, and estate taxes. Let me explain what a trust is. Then I'll show what a trust can do for you for both lifetime and death time planning. As we go along, I'll also describe some other estate planning tools for a more complete plan. A trust is a particular way of owning property. Think of property as a bundle of rights. That bundle consists of two parts, legal title and beneficial title. Legal title determines who controls the property, while beneficial title determines who is to benefit or use the property. Normally, when you own property, whether it's real estate or stocks and bonds or an automobile, you hold both legal and beneficial title. A trust, however, is a special legal arrangement that divides the ownership or title to property into those two parts. A trust is normally evidenced by a written trust document. If you set up a trust, you are called the grantor, or sometimes the settlor or trustor. To make the trust effective, property must be transferred to the trust. The trustee is the person holding legal title. The trustee administers the trust and the trust property according to the instructions you set out in the trust document. In your trust, you also name beneficiaries. They hold beneficial title to the trust property and have the right to use or enjoy the property. Again, according to your instructions. Remember, as the grantor of the trust, you name the trustee, you give the trustee management instructions, you name the beneficiaries, and you specify how and when the trustee is to distribute property to the beneficiaries. There are many different ways to classify trusts, but I'll only be talking about two of the most common types of trust. They are revocable and irrevocable trusts, and they're testamentary and living trusts. A revocable trust is one that you can amend or revoke during your lifetime. An irrevocable trust, of course, is just the opposite. You can't change it or revoke it. A testamentary trust is a trust that you set up in your will and it does not take effect until your death. A living trust is a trust that you establish to be effective during your life. It is sometimes called an inter vivos trust. In this program, we'll be focusing on revocable living trusts because they can help more people accomplish more of their estate planning goals than other types of trusts. With this type of trust, you can name yourself as the trustee and as the beneficiary. That way, you manage the trust assets virtually as though they were not in trust. If for any reason you decided to terminate the trust or you want to transfer some of the assets out of the trust, you could do it. You can be the beneficiary of your own trust while you are living. And as with other types of trust, you can name successor trustees to take over at your death or if you become incapacitated. Of course, as the name implies, your trustee should be someone who you trust completely. With that in mind, let's see how you can use a revocable living trust and other documents for your lifetime planning. As I mentioned before, a good estate plan will include lifetime planning. Why do you need protection during your life? Well, whether we want to face it or not, there is a good chance that most of us will become incompetent or incapacitated during our lifetime. We could get into an accident, suffer from Alzheimer's or senility, have a stroke, or could incur any number of physical or mental ailments that would prevent us from carrying on our daily activities, including our financial affairs. If you haven't made the proper arrangements before you become incompetent, the state will take control of you and your assets. A guardianship or conservatorship will be required. That is where the court appoints a guardian or conservator to make decisions for you and manage your assets for you. You have no input in naming the guardian. In most states, the guardian will have to post a bond, file an inventory of all your assets, and file annual accountings with the court, and get permission to spend your money for you. If you own real estate, even if you own it jointly with your spouse, a court order is usually required before it can be sold or even mortgaged or refinanced. All of your assets become public information. As you can see, a guardianship for most people will require legal fees and other expenses. It's time-consuming and it involves public exposure of your private affairs. On the other hand, if you have a living trust and you have transferred your assets to it, there would be no need for a guardian to be appointed to manage your assets. Legal title would be held by your successor trustee. Your trust could provide that no bond is required, that your trustee does not have to file any inventories or accountings with the court, and that no court supervision is required. In other words, with a trust, you can avoid the time, expense, and public exposure of a guardianship over your estate. In addition to a living trust, you should consider 3 other documents for lifetime estate planning: a durable power of attorney, a living will, and a health care power of attorney. A durable power of attorney is a document in which you appoint another person to act on your behalf for financial matters. It can only be used while you are living. It is durable because it is effective even if you become incapacitated or incompetent. The attorney-in-fact is the title of the person you name to act as your agent. This person does not need to be a lawyer. Most married people name their spouse as their attorney-in-fact, and very often an adult child or a close relative or friend as the alternate. The power of attorney is especially valuable if you do become incapacitated. Even if you don't have a living trust, a durable power of attorney makes it less likely that a court would need to appoint a guardian to manage your estate while you are incapacitated. However, it is not as effective as a living trust because the court can still appoint a guardian, and the guardian can effectively override your attorney-in-fact. On the other hand, a well-drafted, durable power of attorney used in conjunction with a living trust assures you that a court will not have to appoint a guardian to manage your assets in the event of your incapacity. Specifically, your power of attorney should authorize your attorney-in-fact to transfer any and all of your assets to your living trust. This should include your interest in jointly owned property and tenancy by the entirety's property that you own with your spouse. That way, if you do become incapacitated but have not yet transferred some of your assets to your living trust, your attorney-in-fact can do that for you. To further coordinate your durable power of attorney with your living trust, you may want your attorney-in-fact to be the same person as your successor trustee. Another important document you should consider is the living will. With today's medical technology, many people have a fear of being kept alive by extraordinary artificial means. A living will allows you to retain some control over whether your life will be prolonged by certain life-sustaining procedures in specific medical situations. Each state has its own version of the living will, giving you more or less right to specify under what circumstances your doctor may withhold or withdraw certain life-sustaining procedures. A living will is okay as far as it goes, but its scope is generally very narrow. And perhaps more importantly, a doctor is not obligated to follow your wishes. That's why I recommend a health care power of attorney in addition to a living will. A health care power of attorney is a special type of power of attorney where you can name another person, sometimes called a health care agent, who can make health care or medical decisions on your behalf if you are not able to make your own decisions. Your health care agent is usually a family member. The decisions made under a health care power of attorney may be the life and death types of decisions, but they may also be the more routine medical decisions. For powers of attorney, living wills, or health care powers of attorney, you may be tempted to use forms you get out of a magazine or from some other source that may not be written for the particulars of your state. The laws vary from state to state. Even the exact names of some of these documents may vary. Your attorney will be able to draft these documents so that they are valid where you live. Now that we've covered our discussion on lifetime planning, let's focus on death time planning. To have a better appreciation of the benefits of a living trust in this phase of your estate plan, It helps to understand how your estate is affected by probate and wills. For many people, the thought of probate creates great anxiety. You've probably heard all sorts of horror stories about unreasonable time delays, outrageous costs, and other assorted problems associated with probate. In many cases, this anxiety is quite justified. In others, it may not be. As I explained before, your estate is everything you own. When you die, your affairs need to be wound up. Basically, your debts and taxes need to be paid, and your remaining estate distributed to your beneficiaries or heirs. Some of your property may pass to your heirs through probate, and some may pass outside of probate. Your estate is made up of your probate assets and your non-probate assets. Probate means proving a will through the courts. Only those assets that pass under your will are administered and distributed under the supervision of the courts. If you die intestate without a will, many of your assets may still need to go through the courts. This court-supervised process is actually called estate administration, but most people just refer to it as probate, even if there is no will. As I mentioned, all of your property may not have to go through probate. Those assets that do go through probate make up your probate estate. They are sometimes called your probate assets. Your probate assets are normally assets that are titled solely in your name and come under the control of your personal representative. If you have a will, your personal representative is usually called an executor. If you die intestate, he is usually called an administrator. Assets such as real estate, bank accounts, stocks and bonds, and automobiles are part of your probate estate if they are titled solely in your name. If you live in a community property estate, your probate estate may also include one half of your community property. Sometimes property titled jointly is also part of your probate estate. It may be easier to understand what assets are included in your probate estate when I describe examples of non-probate assets. At your death, some assets that you own are distributed to persons without regard to your will or the probate process. They pass directly by operation of law or by contract. These assets make up your non-probate estate. An asset that you own jointly with another that has rights of survivorship, such as a joint bank account, will pass to the surviving joint owner upon your death by operation of law. Another type of non-probate asset, such as life insurance and IRAs, allows you to name a death beneficiary. By contract law, these will be distributed directly to the designated beneficiary when you die. And finally, assets that you have transferred to a living trust will avoid probate. In other words, some of your assets may not be controlled by your will or by the probate process. It is very important to coordinate your probate estate with your non-probate estate to make sure that your desires are fulfilled. A will is a statement you make directing how you want your property to be distributed at your death. There are several benefits in having a will. The most obvious is that you can direct how your probate assets will be distributed. Another benefit is that you get to choose your own executor. The executor is the person who is appointed to administer your estate. The executor has three main functions: to gather and protect your assets, to pay your debts and expenses, including any taxes, and to distribute your remaining assets to your beneficiaries. Another thing that you can do in your will is to name the person you want to be the guardian of your children in the event you are the last surviving parent. The guardian is the person who is appointed by the court to raise your children until they are legally adults, which is 18 in most states. A will has some other functions too, and every serious estate plan should have a will because of the control it provides. If you die with a valid will, you are said to have died testate. If you die without a valid will, you will have died intestate. If you die intestate, the state takes control. It determines who gets your property, who will be the administrator of your estate, and who will be the guardian of your children. As important as that is, however, it's also important to remember what a will does not do. Upon your death, your will controls only your probate estate. It does not control life insurance or similar assets unless your estate is designated as the beneficiary. It does not control assets that are jointly owned with right of survivorship. It does not control assets in a living trust. And a will does not avoid probate. In putting together your estate plan, you should determine whether or not you want to avoid probate, and to what extent. You should also decide which methods to use. Probate expenses will vary from state to state because there are differences in court costs and in the complexity of the legal process. Court costs are generally based on a percentage of your probate assets, and in some states, this can add up to a hefty sum. Further, the more complicated the legal process, the more you are likely to pay in attorney's fees. There are also built-in time delays in the probate process that can delay the distribution of assets to your loved ones. So, early on in developing your estate plan, you should determine whether the probate expenses and the required time delays in your state make probate avoidance a worthwhile objective. If you decide that avoiding probate is one of your estate planning objectives, there are various ways of achieving your goal, and some of them are better than others. For instance, some people want to use jointly owned property as a way to avoid probate or for convenience. This can cause some serious problems that you may not have anticipated. You lose control over how some jointly owned property passes at your death. And some jointly owned property needs the signature of both owners. One of the joint owners could become incompetent or could refuse to cooperate. Even if the joint owner is totally trustworthy, if he has judgment creditors or is involved in a divorce, or if he dies before you, some of your property could be lost. Further, if you have a taxable estate over the applicable exclusion amount, having jointly owned property could cost you substantial estate tax savings. As you can see, how you title your assets is a critical estate planning decision. In general, it's better to have most of your assets titled solely in your name. But since everyone's circumstances are different, you should consult with your estate planning attorney for which assets you should title jointly and which you should not. For married couples, I'll be giving you more ideas on how to title your assets later on in the program. Another way that people often avoid probate is by naming individuals as the death beneficiary of life insurance or retirement plans. Remember, if you name an individual, such as your spouse or child, as your beneficiary of life insurance or similar asset, your will does not control those benefits. Some folks will name one child as the life insurance beneficiary with the expectation that that child will use the funds to pay funeral expenses, pay off creditors, or distribute the funds among several individuals. The beneficiary is not legally bound to do any of those things. On the other hand, some people name the estate as the beneficiary. In that case, the proceeds are controlled by the will. They go through probate and are subject to the claims of your creditors. The better way to handle death benefits in many cases is to name your trust as the beneficiary. As you can see, there are easy ways to avoid probate with some assets, but other, more important goals may be lost. If done properly, a living trust can be a great tool for avoiding probate. Upon your death, your living trust acts like a will, except that the assets in trust do not go through probate. Like a will, your living trust directs how your trust assets will be administered and distributed upon your death. Instead of your executor handling those assets, under court supervision, your trustee administers and distributes the trust assets free of court interference. And that is based on the instructions you have given in the trust. For instance, you can provide that the assets will be distributed outright to your beneficiaries, or you can have the assets retained in the trust for a period of time, or until certain events occur. So, with a living trust, you can avoid probate for those assets that would otherwise go through probate. But to accomplish that, you have to transfer the title to those assets to your trust before you die. Likewise, for assets such as life insurance or retirement plans that normally avoid probate, if you name your trust as the beneficiary, you can control the distribution much more effectively. Your life insurance policy or retirement plan normally has limited options for designating contingent beneficiaries. Your trust can be customized to suit your wishes for distribution of these death benefits. And if you name your trust as the beneficiary instead of your estate, those proceeds will not be subject to the claims of your creditors. Think of your living trust as a new car. When you drive it off the showroom floor, it has only enough gas and oil in it to get you a few miles. If you don't keep it full of gas and oil, it won't get you where you want to go, no matter how much you paid for it. Your assets are the gas and oil, and your estate plan is your roadmap. If you don't transfer the title to your assets to your trust before you die, your trust won't avoid probate for those assets. And if you don't name your trust as the beneficiary of life insurance and other assets with a death beneficiary, your trust won't be able to control the distribution of those proceeds. You can have a Mercedes-Benz and a Rand McNally map, but you won't get where you want to go without gas and oil. I mentioned earlier that every serious estate plan should have a will. Even if you have a living trust and have transferred all of your known assets to it, there may be a few assets that have not made it into your trust. You never know what assets you will own at the time of your death. Your will should name your living trust as the beneficiary. This type of will is called a pour-over will because all of your probate assets will pour over into your living trust after going through probate. Up to now, we've been discussing your probate estate and your non-probate estate. Your gross estate and your taxable estate are closely related concepts. Essentially, your entire estate, probate and non-probate combined, is your gross estate for estate tax purposes. Most of us are only too familiar with federal income taxes, but after a lifetime of paying taxes on your income, you and your estate are also subject to a federal gift tax and estate tax when you transfer your assets during your life or upon death. Most states have a gift tax and an inheritance tax, but they are generally less significant than the federal taxes, and each state is different. So we won't be covering them in this program. To understand how to save estate taxes with trust, you need to understand two important estate tax concepts: the unified credit and the marital deduction. The federal estate tax and gift tax are under a unified credit system. Each U.S. citizen and resident alien has a unified tax credit that allows you to make combined lifetime gifts and death time transfers without paying tax on amounts of up to $1 million. This combined tax credit is sometimes called the unified credit or the applicable credit amount. The exact amount of the credit depends on the year the gifts are made and the year of death. The amount that you can pass under the credit is called the applicable exclusion amount. The applicable exclusion amount gradually increases until the year 2006. In other words, you can give away up to the applicable exclusion amount without paying a tax, whether it's during your life or upon death. You can also make lifetime gifts of up to $10,000 per year to to as many different people as you want without paying a gift tax or using up any of your credit. This $10,000 amount is called the annual exclusion, and it will be adjusted for inflation in the future. If you give someone more than the annual exclusion in any one calendar year, you will be using up part of your credit, so that at death you won't be able to pass the full applicable exclusion amount tax-free. For ease of discussion, we'll assume that at death the entire credit is still available. Further, for all our examples, we will assume that the applicable exclusion amount is $700,000. Even though the exact numbers will vary depending on the year of death, the principles illustrated will be the same. So, for example, if your death occurs in 2002 or 2003 and your taxable estate exceeds $700,000, your estate will have to pay an estate tax. The tax rates on amounts over $700,000 start at 37% and go as high as 55%. But there is a catch. Your taxable estate is determined in part by deducting your debts and administrative expenses from your gross estate. There is also a deduction called the marital deduction. Your estate gets a dollar-for-dollar deduction for everything that passes to your spouse at your death. No matter how large your estate is, if you leave everything to your spouse, there will be no estate tax because your taxable estate is reduced to zero. That's fine, except you are not using any of your unified credit. Then, when your spouse dies, her estate has only one applicable exclusion amount to pass up to $1 million tax-free to your heirs. I'll be showing you several examples to help illustrate how all this works. To make the discussion easier, with married couples, let's assume that the husband dies first and that both spouses want their children to inherit when the second spouse dies. Let me show you an example. Assume your estate is $700,000 and your spouse's estate is $700,000 for a total of $1.4 million. If the husband dies in 2002 and leaves $700,000 to his wife, there is no tax because of the marital deduction. Here's the catch. When the first spouse dies, he has to leave $700,000, or whatever the applicable exclusion amount is for that year, to someone other than the surviving spouse in order to use all of his unified credit. In other words, none of the estate planning for tax savings benefits the couple. It benefits the next generation, or whoever will ultimately inherit your estate after the death of the second spouse. And to save taxes for them, the surviving spouse is going to have to give something up. Let me give you some different scenarios so you can decide whether it's worth all the trouble. We've seen one example where the first spouse to die left everything to the surviving spouse. There is a big tax cost going that route. Now, let's see what happens at the other end of the spectrum. Again, let's assume that the husband dies in 2002 and the wife dies in 2003. When the first spouse dies, he could leave $700,000 to the kids. The surviving spouse has her own $700,000. There would be no tax when the first spouse dies because of his applicable exclusion. If the second spouse still has $700,000 when she dies, there would be no tax because of her applicable exclusion. Although $1.4 million will have been passed on to the kids without taxes, the surviving spouse may be left with less security than you are comfortable with. Fortunately, there is a compromise solution between the two extremes of leaving everything to your spouse versus leaving $700,000 or whatever the applicable exclusion amount is to the kids. When the first spouse dies, he can leave $700,000 to a special trust within your living trust. This special trust can stipulate that the surviving spouse is to get all of the income from that part of the trust, and under certain circumstances, the trustee can even distribute principal to her. This trust is sometimes called the Credit Shelter Trust because it protects and uses the unified credit of the first spouse to die. Usually, no more than the applicable exclusion amount is put into this trust. The kids, or whoever the husband designated in his trust. Further, the wife's $700,000 also passes to the kids tax-free. Remember, this can work the same way if the wife dies first. For the typical married couple with more than $700,000, this is the basic, most common estate tax savings technique. I'll show you a couple different ways to implement the Credit Shelter Trust. One way is to simply provide in your trust that the applicable exclusion amount is to pass to the Credit Shelter Trust when you die. This is probably the better way for larger estates where the surviving spouse will be left with enough other assets for her comfort and security. By the way, if you have more than the applicable exclusion amount in your estate, you can leave the excess outright to your spouse, or you can leave it in yet another trust for her benefit. Another way to implement your Credit Shelter Trust is to let the surviving spouse decide after your death how much should pass into the Credit Shelter Trust. This is done by leaving everything in your trust to your spouse, with provisions stating that to the extent your spouse disclaims any part of her bequest, it passes to the Credit Shelter Trust. This method offers much more flexibility than the first one. The surviving spouse can choose how much, if any, to put into the Credit Shelter Trust based on the circumstances at the time the first spouse dies. I like this option when the couple's estate is less than $2 million because it allows more security for the surviving spouse. There are drawbacks to both methods. Which way you choose depends on several factors, such as the size of your estate, the amount you want your surviving spouse to have outright, the ability of the surviving spouse to be able and willing to make critical choices, and whether you have children from a prior marriage. In other words, tax savings is not the only goal of estate planning, and there are other types of trusts that you can use in conjunction with the Credit Shelter Trust. And these can also be included in your living trust. Because your situation is unique, it's all the more important that you discuss your goals and the various options with your estate planning attorney or other advisors. One more point to make is that these tax savings features work in a testamentary trust as well as in a living trust. It's just that with the living trust, you also get the lifetime planning features and the probate avoidance features we discussed earlier. The credit shelter trust may not be right for everyone, or it may not be enough. There are other ways to avoid estate taxes. Perhaps the simplest way to avoid paying estate taxes is to spend it all before you go. For most people who have worked hard to accumulate their wealth, that idea doesn't quite fit. Although I can't explain all the other tax savings methods, I will mention 3 of them. Short of spending it all, you can give it away. Now, I don't recommend this for everyone, but for some people, it makes sense. First of all, you should be in a position that your gifts won't compromise your security. If it's appropriate for you, you may want to start a gifting program to reduce your taxable estate. As I mentioned earlier, you can give up to $10,000 per year to as many persons as you want without an estate or gift tax consequence. The recipient of your gift is called a donee, and if you are married, together you can give $20,000 per year per donee. For example, if you and your spouse have 3 children and 2 grandchildren, together you could give $20,000 to each child and each grandchild and reduce your estate by $100,000 per year. You could do this without paying any taxes, without using any of your unified credit, and without having to file a gift tax return. Giving to qualified charitable organizations is another way to reduce your taxable estate, and it seems to be gaining in popularity. Some folks have charitable intentions and will simply make charitable gifts without extra incentives. However, for many of us, our charitable motivation is assisted by the tax write-off. This works in estate planning as well as income tax planning. To make charitable giving even more attractive, there is another special type of trust called the Charitable Remainder Trust. This is an irrevocable trust separate from the living trust we've been discussing. With a Charitable Remainder Trust, you can provide income to your loved ones for their lifetime and leave the remainder to a charitable organization. In some cases, when you factor in the tax savings, your loved ones end up receiving about the same value as if you gave them the property outright. The net effect is as though you are paying taxes directly to charities of your choice instead of to the federal government. So if you want to make a difference with your estate, you should really consider this option. By the way, some financial planners specialize in charitable giving. There is yet another way to use trusts to save estate taxes. Like the Charitable Remainder Trust, it involves an irrevocable trust. This one is an irrevocable life insurance trust. Again, this technique is not for everyone, but when it is appropriate, it is so sweet. It works like this. You set up an irrevocable trust. Then you have the trust buy life insurance. Since you are not the owner of the life insurance, when you die, the insurance proceeds are not part of your gross estate. So you have effectively increased the size of your estate without increasing the tax. You've also added liquidity to your estate, which may be needed to pay estate taxes. For example, if you purchase a $500,000 policy, you may end up paying 40 to 50% of that in taxes. On the other hand, if your life insurance trust purchases the $500,000 policy, all $500,000 goes to your loved ones. That is some tax savings. I've shown you several ways to save estate taxes, but some of those may have income tax consequences that need to be taken into consideration with your estate plan. If you have ever sold your real estate or stock, you are familiar with the capital gains tax. Basically, if you sell an asset like real estate or stock, you pay a tax on the gain. The gain is measured by the difference between the sales price and the basis of the asset. The basis is generally the cost of the asset, what you paid for it. If someone inherits an asset, their basis in that asset is its value at the date of death. This is called stepped up basis. And for assets that have a low basis, this is a tremendous benefit. However, if you give someone an asset, their basis in that asset is the same as your basis. This is called carryover basis. For instance, let's say you have a house that you purchased 30 years ago for $25,000, and now it's worth $100,000. Your basis is $25,000. If you sell the house, you pay capital gains tax on the $75,000. If you give the house to your children and they sell it for $100,000, they will pay capital gains on the $75,000. If your children inherit the house from you and the house is worth $100,000 at your death and they sell it for that amount, there's no gain, no capital gains tax. The moral of this story is that you need to be careful before you start giving your property away. You might save estate taxes, but lose on income taxes. This is another example of why it's important to get professional advice when dealing with an estate tax planning situation. Another area where estate taxes clash with income taxes is IRAs and qualified retirement plans. These are great from an income tax perspective while you're living, but they can be a nightmare for estate tax planning. I'll be referring to IRAs, but the same rules apply for any qualified plan, such as your 401k. The funds in your IRA are not income taxed until they are taken out. To the extent you take the funds out during your life, you pay tax on them. If you die, your beneficiary pays income tax on the funds when he or she takes them out. Your IRA is also part of your gross estate, so your estate pays estate tax on your IRA when you die if your taxable estate exceeds the applicable exclusion amount. So if your beneficiary pays state and It's beyond the scope of this program to discuss this in too much detail, but I can give you some general ideas to lessen the tax burden. There are two essential factors to understand. First, who you designate as your death beneficiary can have a big impact on the distribution options available. For instance, if you name your spouse as the death beneficiary, he or she has the option to roll the retirement plan over into their own IRA. Only the spouse has this rollover option. By rolling it over, the funds continue to grow free of income taxes until the funds are drawn out. Your beneficiary may also have the option to take the distribution in installments over his or her life expectancy. So if your child is your death beneficiary and is 45 years old at your death, he may have a life expectancy of 30 years. He may be able to take the IRA benefits out 1/30th per year for 30 years. Again, this has the effect of letting most of the funds continue to grow tax-deferred for years. If you name your living trust as the beneficiary of your IRA or qualified plan, your trust doesn't have a life expectancy, so it is more difficult for the beneficiary to take distributions in installments. The second factor to understand with retirement plans is that all retirement plans are not alike. While the law allows the various distribution options I've just described, many retirement plans do not permit your beneficiaries to take advantage of them. Generally, employer-sponsored plans such as 401ks are more restrictive than IRAs, so when you have a chance, it's usually better to roll over your employer plan to an IRA. But you may have to shop around for an IRA that will accommodate the distribution options you want. If you have a substantial IRA or qualified plan and you have a taxable estate over the applicable exclusion amount, you should find an estate planning expert who is familiar with these various options. The last income tax consideration has to do with your revocable living trust. If you are the trustee of your own revocable living trust and are to receive all of its income, then it will be classified as a grantor trust for income tax purposes. This means that for income tax purposes, the trust is ignored and the assets are treated as though they are still titled in your name. All the income is reported under your Social Security number. The trust does not need to get a taxpayer identification number. It simply uses your Social Security number. At your death, the trust may need to get its own number and file income tax returns. What can a revocable living trust do for me? The typical revocable living trust that we have been discussing has at least three purposes. First, during your lifetime, it serves as an excellent asset management device, especially if you become incapacitated. Second, at your death, it allows your assets to avoid probate. And third, you can use it to reduce or avoid estate taxes. Should I get a revocable living trust? This is really a matter of personal choice. As a rule of thumb, I would say that the larger or more complex your estate is, the more likely that a revocable living trust is a good idea for you. Although a durable power of attorney can fulfill some of the functions of asset management, a living trust is generally more effective. If probate avoidance is important for you, then the living trust is very worthwhile. However, for estate tax savings, a testamentary trust may work just as well as a revocable living trust. If my spouse and I decide that we want a revocable living trust, should we each get our own trust? There's a difference of opinion within the estate planning community as to whether a couple should have a joint trust or separate trust. My personal opinion is that in most cases, each of you should have your own trust. This avoids potential problems with tax issues and non-tax issues that could arise with a joint trust. I've heard horror stories about people who have had their inheritance tied up in trusts for years. If I want to use a trust in my estate plan, how can I make sure that my beneficiaries are treated fairly? First, about those horror stories. It could be that the person who set the trust up knew exactly what he was doing by keeping assets in trust. Perhaps the beneficiary was estate planning attorney what restrictions you want and do not want on the assets that are placed in trust. Then, when your trust is drafted, review the document with your attorney to make sure that it has been drafted to meet your wishes. If I have young children or even adult children who could not responsibly handle a sizable inheritance, what can I do? Instead of leaving an inheritance, you leave it in trust. In the trust, you can provide a variety of uses and restrictions for your property. If your child is young, you may provide that their inheritance will stay in trust until a certain age, say 25 or 30, or that it will be distributed to them incrementally, such as one half at age 25, the other half at 30. Basically, you can stipulate how and when the trustee can distribute the funds to the beneficiary. If I want a living trust for probate avoidance, a credit shelter trust for tax savings, and trust for minors or incompetents, do I need to have 3 or 4 different documents? No, all of these trusts can be part of your living trust. Think of your living trust as an umbrella that has sub-trusts under it or within it. Your living trust can have provisions that cause other trusts to come into existence upon certain conditions or under certain circumstances that you specify. A testamentary trust can have some of the same types of sub-trusts, such as the credit shelter trust and the trust for minors. What does the trustee do with the assets that are in the trust? Unless you specify otherwise, the trustee is generally under an obligation to invest the trust assets prudently. What is the difference between an attorney-in-fact, an executor, a trustee, and a guardian? An attorney-in-fact is the person you appoint in your power of attorney to assist you with your financial affairs. The attorney-in-fact can sign for you and act on your behalf. The power of attorney terminates automatically at your death, so your attorney-in-fact has no authority to act for you the moment you die. In a sense, your executor picks up where your attorney-in-fact left off. The executor is the person you have named in your will to probate your will and administer your estate. your executor has no authority until after your will has been probated and the probate court officially appoints him. After your estate is closed, your executor is discharged and has no more authority. A trustee is the person you have appointed in your trust to administer the assets in your trust. If you have a living trust, your trustee does this during your life and after your death. In a typical living trust, you may be your own trustee, and upon your death or incompetency, a successor trustee would take over. A guardian is the person appointed by the court to be responsible for your minor child or an incompetent person. With respect to minors, the court will almost always appoint the person you have designated in your will. Some states have two types of guardians: guardian of the person, to be responsible for the person, and guardian of the estate, to manage the person's property. Whenever you are going to name an attorney-in-fact, an executor, a trustee, or a guardian, it's best to provide for one or two alternates. Now you're ready to put together your estate plan. One of the first things you should do is gather information about your loved ones and your assets. You can use the enclosed estate plan information sheet to assist you. When you list your assets, you don't have to be exact about the amounts, but you do need to know exactly how they are titled. Once you have gathered your information, begin making the framework for your plan. Start with the basics and define your objectives. I would start with the non-tax aspects. Who do you want to take your property? Be sure to plan for contingencies in the event a loved one dies before you. Is probate avoidance important to you? Who should be your executor and your trustee? If you have minor children, who should you name as the guardian? You may want to name the same people for these positions. And be sure to have one or two alternates for each of these positions. If you want to avoid estate taxes using the Credit Shelter Trust, what method do you want to use to implement it? After you have given your estate plan some thought, you should seek the advice of competent estate planning advisors to discuss your objectives. They can give you personalized advice, assist you in finalizing your plan, and make it all fit together. Once you have done this, let your estate planning attorney prepare the appropriate documents. After your estate planning documents have been prepared, you need to follow through to make your estate plan work. If you have made a revocable living trust, transfer your assets to it. This is called funding your trust. If you are married and you have a taxable estate over the applicable exclusion amount, you should equalize your estates as much as practical. This means that you should title your assets in such a way that both of you have at least the applicable exclusion amount in your individual names, or if you have revocable living trusts, in your individual trusts. Be sure to coordinate your death beneficiary assets with your will and trust. In other words, name the proper beneficiaries for life insurance and retirement plans. Implementing your plan is critical. If you don't follow through, or you do so incorrectly, your estate plan could be ruined. Get the advice and assistance of your estate planning advisors to help you with this important part of the process. I hope this program has given you some valuable insight and helped you in your decision to make an estate plan and whether or not to include trusts as part of your plan. And while I've tried to cover most of the topics associated with living trusts and estate planning, please remember that no program or book can possibly cover every circumstance or detail on the subject. After you've gathered all your information and put together a framework for your estate plan, you should consult with an estate planning attorney. An attorney experienced in this area can not only draft wills, trusts, and other documents to meet your needs, but can discuss your plan in detail and offer you alternatives and solutions. Most attorneys can draft a simple will, but you may want to find an attorney experienced in estate planning. If you don't have an attorney, check your local yellow pages under attorneys, or ask your financial planner or your friends for a recommendation. In conclusion, let me leave you with a few final tips. You're bound to have conflicting goals. Keep them in perspective. Some things are more important than saving taxes. Your plan does not have to be an all or nothing proposition to be successful. And there are various ways of achieving a goal, and some of them are better than others. And remember, the more prepared you are when you talk to your estate planning advisors, the better plan you'll have, and the more you'll enjoy the peace of mind that you and your loved ones deserve. Thank you, and good luck.